Hello, my name is Lucy Loiseau and I'm a partner at the International Family Law Group. This podcast today will be looking at Schedule 1 claims under the Children Act 1989 that have an international element. We'll also touch briefly on TOLATA cases. I'm a colleague at IFLG of David Hodson OBE, who is the author of the International Family Law Guide 2015-16, on which the content of this podcast is based. So turning to Schedule 1 claims under the Children Act 1989. What do these claims cover? Well, by Section 15 of the Act, basically they cover financial provision for children. These applications are commonly made by unmarried parents and step-parents, but they can also be made by three other categories of people. They can be made where a child or the provider are outside of the jurisdiction of England and Wales, i.e. they're not habitually resident here. They can also be made where the income of the non-resident parent exceeds the maximum allowance from the Child Maintenance Service. And thirdly, these applications are made where it concerns educational or disability costs, and occasionally children over the age of 18 make these applications in their own right. So who can apply under Schedule 1? First of all, a parent. Secondly, a step-parent. Thirdly, a guardian. And fourthly, the holder of a child arrangements order. Sometimes a child, as I say, that's over the age of 18 can also apply for these orders. If a child is applying, however, they need to show that they are in further education or undergoing training for a trade. So let's look at the jurisdiction of Schedule 1 cases, and particularly relating to the international element. There have been significant jurisdictional changes following the introduction of the EU Maintenance Regulation on the 18th of June 2011. Previously, the jurisdictional criteria were found in paragraph 14.1 of the schedule. Now this has changed, and this has been substituted by the EU Maintenance Regulation, and jurisdiction is now found by Article 3 of the Maintenance Regulation. So in summary, jurisdiction will exist if one of the following apply. The maintenance creditor or receiving party is habitually resident in England and Wales. Secondly, if the respondent is habitually resident in England and Wales. Or thirdly, if the Schedule 1 proceedings are ancillary to parental responsibility referred to in EU legislation. So what we mean by this is if there are welfare proceedings underway under the Children Act 1989. So what orders can the court make under Schedule 1? Well, there's a whole variety of orders that the court can make, but they're not as significant and substantive as those under the Matrimonial Causes Act. But they have the ability to make a settlement order or a transfer of property order. Now, a settlement order is an order where one parent settles the property for the benefit of the child or children. A transfer of property order can be outright, but often in these cases the property will be held on measure terms, and so they'll revert back to the transferor when the child reaches the age of 18. One thing for practitioners to bear in mind is the court only has the power to make one transfer of property order, so ensure that you fix your case and prepare your case wisely in this regard. The court also has the ability to make lump sum orders. There isn't such a concept in Schedule 1 proceedings as the clean break, so you can come to court and make a number of different applications under Schedule 1 during a child's minority. The court can also make periodical payments orders, but its ability to do so is limited under Schedule 1. It can only make orders for periodical payments where it either recites an agreement that the parties have reached voluntarily, or secondly, when the non-resident parent's income is above the CMS threshold, which at the moment is £156,000 gross per annum. The court can also make orders where the child is or will be receiving training or is undergoing education. The court can vary existing periodical payments orders as long as there has been no assessment via the CMS. Periodical payment orders usually last until the child is 17, but they can sometimes extend to a greater period of time to cover a child's further education. The court also has the ability to order carer's allowance and also to order school fees orders and also make orders for medical cover for children. So it's important that you look at all the possible provisions available for your client. Finally, a very brief word on Talata. This is a very difficult and complex area of the law, and international Talata cases are even more complex. Careful consideration must be given as to whether or not an English court can deal with foreign assets, and you should take advice early on this. Enforcement in these cases is absolutely fundamental. If you require assistance on any of the issues discussed in this podcast, please do not hesitate to contact me. Thank you.